Worcestershire County Council and the Secretary of State for Health and Social Care and another.
Yes. Good morning. Mr. Bewley, just before we start, a couple of things. Firstly, on a logistical point, we'll rise at 5 to 1.
5 to 1.
Because there's going to be a fire alarm at 1.
Right.
And so rather than us get involved in shouting over the loudspeaker announcement, we'll rise at 5 to 1, and then everybody's got a chance to get away before the practice actually
I'll try and remember that, but I no doubt.
Well, I will have an eye on the clock, so we'll go by that clock, which is roughly right.
Yes.
Okay, so that's the logistical point.
Yes.
And as far as the appeal itself is concerned, you can assume that we have a lively appreciation of what the issues are.
Yes.
We've read the judgment, the skeletons, and the authorities.
Yes.
So you can take all of that as read.
Right.
And speaking for myself, I think that the thing I'm going to be most interested in, potentially at any rate, it is how and why you say that the amendments to section 117 make so much difference.
Yes.
Because that, I think, is, in view of the fact that there is an authority on this section,
the Hertfordshire
before
case.
It was amended, which you don't want us to follow, it must mean that the amendments are of great significance.
Yes,
If we're not persuaded by the amendments, if we're not persuaded that the amendments have that significance, then obviously on the first ground, at any rate, then Hertfordshire is binding.
Yes.
But if you're right, then it isn't. So that, I think, means that is an area that we would be particularly interested in. You'll take your own course, but I thought I would make
that's very helpful to know
at the outset.
I mean, I'll take my course, which would have involved taking you through some of the background statutory provisions and so forth. But if you think I'm going too slowly, perhaps you can tell me.
I was going to just add to what my lord has said, and said he has read the authorities in greater detail than I have.
Right.
So, for my part,
you wouldn't mind having a bit of help.
Such assistance as you think you can provide on those.
I'm grateful.
Points.
I mean, what I'll do is I'll do what I've written down, as it were. But if you think I'm either going too fast or too slow or missing whatever it is, no doubt you can guide me along the way, and I'll do my best.
And presumably you've talked about the timetable, and you're entirely happy that.
Yes.
I mean, it seemed to me to be relatively generous, but let's see.
Well, I'm content. We're certainly content with the day. I mean, that's That's
fine.
Yeah.
So on that basis, hopefully it won't be you, but Mr. Parkhill who will be affected by the 5 to 1.
I had thought it might not be, but let's see how we go. But I think we're both content we can do it in the day, so I'm grateful. My lords and my lady, then, I was going to say, but perhaps I don't need to, that I appear for the appellant and that Mr. Parkhill appears for the respondent. You've got a core bundle, which includes the skeletons. You've got an authorities bundle. That's it. There's not a supplementary bundle. This is, again, forgive me if I'm labouring this is my appeal from the decision of Mr. Justice Linden, in a judicial review of the decision of my client about the ordinary residence of a service user in a dispute between two local authorities, Swindon and Worcestershire. The court will no doubt appreciate the reason that sort of decision matters is because the ordinary residence question decides the allocation of responsibility for the provision of care, which is likely to be very expensive, and it can fix. That might be in the region of 10 or hundreds of thousands of pounds per year, and obviously that can fix it over someone's lifetime.
Well, we understand that these disputes are becoming more common.
Indeed.
This is the second one I've sat on in the last 4 or 5 months.
Right. Okay. Well,
and we understand about the money, although it is a shame that there isn't a better way of resolving the dispute than judicial review.
No, I mean, that may well be right, my lord. Although I think it's right, we would say, in this particular case, there are 2 points of general principle which are of, the court may or may not have a view about their difficulty, but they are of some importance. So it may be that this is a case that needs to be looked at by this court. With that in mind, then, you indicated you read in, I was going to say very briefly about the facts. The facts are set out in my skeleton, they're set out in the judgment, they're set out in the review decision. But, for example, in the judgment, they're set out at paragraphs 5 to 14, pages 68 and 9 of the appeal bundle. But rather than turn that up, we can strip the facts right down in this way. If I just invite you to turn up the chronology for a moment, that's at page 62 of the appeal bundle.
Yeah.
Because you don't need any colour, as it were, at all.
Yeah.
So we're dealing with the ordinary residence of the service user JG. She is detained, as we're told in the chronology. Prior to this, she's living in Worcestershire. She's detained under Section 3 of the 1983 Act for the first time in March 2014. And she's discharged in July of that year. Now, at that point, Worcestershire accept responsibility. So the placement, which is in Swindon, is funded by Worcestershire pursuant on the basis that they owe her a duty under Section 117. She then stays effectively, she's moved around, but she stays in Swindon until she's redetained for the second time. There's a moot point about whether you need to look at May or June, Section 2 or Section 3, but we need trouble about that. Nothing turns on it. And therefore, whichever of those dates is relevant, she's redetained for the second time on either May or June, and she remains in detention until November 2015. That's the second period of detention. So the question which arises, certainly for the purposes of issue 1, or ground 1 of the appeal, is where was she ordinary resident immediately before that detention? The second detention. The second detention. The two candidates are obviously either Worcestershire or Swindon. Swindon on the basis...
Not like Cornwall, where a third candidate comes up on the rails and becomes the answer, even though it seems surprised.
Well, my lord, I think it is actually... The third candidate in Cornwall, the authority that's originally in the frame is Cornwall itself.
Yeah.
But that's because of a decision called ex parte Vale, which both the Court of Appeal and the Supreme
either
Court...
Cornwall or South Gloucestershire.
Yes.
And suddenly the winner was Wiltshire.
Yeah. Well, so Wiltshire, so Worcestershire and Swindon in our case are analogous to South Gloucestershire and Wiltshire in the Cornwall case. Cornwall it's called Cornwall because they were the claimant, but in a way they're out.
I get that. Okay. Yeah. So it's where she was ordinarily resident before the second detention, so in May or June.
Exactly. And so obviously the two candidates, as I've said, and the reasons, the putative reasons why it might be one or the other. Well, Swindon, that's where she actually was, and Worcestershire, well, they had placed her there in a nutshell.
And we're paying for her there.
Sorry.
And we're paying for.
And we're paying, and indeed we're paying for it. Exactly right, lady. Yes. That's all. I think that's all I need to say about the facts. There's then a process of dispute goes to the Secretary of State. There's a judicial review. I don't need to say anything more about that. Then the statutory provisions. Now the court's indicated, or some members of the court more than others have looked at them. As I say, I'll take my course, and you can tell me. I hope if I'm slightly over-labouring it. We do need to look at more than one statutory scheme here. And I'm going to start, if it's acceptable to the court, with the National Assistance Act 1948, which is in tab 1 of the authorities, because it's critical to understand these provisions because they're so central to Cornwall. So if we can just turn up tab 1. This is the statutory provision, section 21, under which significant... I hesitate, it might be most, but I hesitate to say that with certainty. At any rate, significant amounts of general community care were provided to adults prior to the Care Act in 2014. So there's a duty, we needn't be too troubled with the details, but it's in subsection 1, subject to and in accordance with the provisions of this part. A local authority may, and with the approval of the Secretary of State, and to such extent as he may direct, shall make arrangements for providing, etc. And then there are conditions which must be met for the duty to be triggered, but we're not concerned with that. Just for your note, the judge asked a question about this below. it's a may and then to such extent as the Secretary of State directs shall. The Secretary of State had, at all material times when this was the main statute, so directed by way of some, and that's recorded in the judgment book. I don't think you need to be troubled with the details. So that's the duty. But what is of more significance for our present purposes is the ordinary residence provisions in section 24. So that's a couple of pages on, it's page 6 in the authorities. Section 24, 1, the local authority under this part, empowered, etc., shall, subject to the following provisions, be the authority in whose area the person is ordinarily resident. So ordinary residence is made the kind of governing concept, as it were, for allocating responsibility. And note, please, that in this statute, it's in the present tense. So potentially, responsibility shifts with the individual. If the person starts off in, I'll come back to Camden a lot, it just happens to be where I live, but it's just used. If the person starts off in Camden, but they decide to move to
Islington.
Westminster or what is it? Islington.
No, Islington.
Yeah.
Sorry. If you lived in Camden, you would want to move to Islington.
I see. Trying to resist moving to Islington at the moment. It happens. Yeah. If the person is, fine, they move to Islington.
So the concept of ordinary residence is very much alive and kicking before the 83 Act.
Oh, absolutely. Yeah, absolutely. And it goes back. I mean, if you go, I mean, we need to do it, but you can go back. It goes back before community care. It's a concept used in tax statutes and all sorts of places. Yeah, absolutely.
Yeah, well, SHAR is a tax statute.
No, SHAR is an education grant.
Oh, education, yes.
But SHAR draws on tax cases. My lord is, yeah. And while, I mean, query whether we need to say this, but one nuance about the concept of ordinary residence, it does get used for slightly different purposes. So here, in all the statutes we're interested in, it's used to allocate responsibility amongst public authorities. There can be circumstances in which it performs a different function. So, for example, in the tax statutes, it imposes a liability, or it's used so you can be liable to tax because you're ordinarily resident. And in, for example, SHAR, which is an education grant case, it's about entitlement. So the person will only be entitled to the benefit, in that case an education grant, if they are ordinarily resident in a particular place.
Yeah.
Here it's not performing that function, because even if the person is ordinarily resident nowhere, they still get the accommodation under Section 21. It's just that you have to use a different technique to find out who's responsible. And that can matter because it means that sometimes you take a different approach, for example, whether illegal presence disqualifies you from ordinary residence and matters of that kind. None of that matters for our case, but it's just there in the background in the cases and it's worth being aware of. But the point I just wanted to draw attention to on subsection 1 is, in this statute, it's present tense. So as I say, if you voluntarily move your residence, having become entitled to services, then the responsible local authority could potentially shift. But subsection 5 is very important because that's the deeming provision. Where a person is provided with residential accommodation, and then please note, under this part of the Act, so it's got to be accommodation under Section 21 effectively, he shall be deemed, and again, important words, for the purposes of the Act, to continue to be ordinarily resident in the area in which he was resident immediately before. I won't read out the whole thing. So that's the much vaunted deeming provision. Its effect, the policy reason for it is, I think, obvious enough. Come back to Camden and Islington. I become entitled to services from Camden, accommodation from Camden. Camden say, actually, we haven't got a suitable care home for you in our area, but there's one over the border in Islington. And so they place me there. Because subsection 1 is expressed in the present tense, it would, at that point, the responsibility would shift to Islington, and that would obviously create very undesirable consequences, because Camden then would have a motivation to put me outside of Borough, precisely because they'd then lose the responsibility for paying for my care. So the deeming provision avoids that, and the way it does it is it fixes a point in time at which my ordinary residence is determined, and thereafter, the fact that provided I'm being provided with accommodation under the Act, thereafter responsibility doesn't shift. Now that notion of fixing the point in time is in my submission very important, because my submission to you is that you'll see the same, albeit by a different drafting technique, you see the same thing in the Mental Health Act as it now stands. So that's the National Assistance Act, hopefully clear enough in the way it works. We can then take some parallel statutes relatively quickly. The other legislative scheme that's important for Cornwall is the Children Act. You see effectively the same thing by slightly different drafting techniques. So if you go please to tab 4. The duty, analogous to section 21 in the National Assistance Act, is in section 20 now. That's, for example, the duty that was engaged in Cornwall. And that's a duty to provide children in need with assistance of various accommodation. And there can be various reasons for that, but they can include, for example, children with specialist needs, as was the case in Cornwall. So that's the basic duty. Subsection 2, then the way in which you allocate responsibility is a bit more complicated, but it comes to the same thing. So subsection 2, where a local authority provide accommodation under subsection 1 for a child who is ordinarily resident in the area of another local authority, that other local authority may take over the provision of accommodation for the child within, and then there's a period and so forth. Now that, of course, doesn't appear in itself to make them responsible. It just gives them the option of taking over. But the teeth behind that is then to be found in section 29(7), which is page 43 of these authorities. And subsection 7 says, where a local authority provide any accommodation under section 21 for a child who was ordinarily resident within the area of another local authority, ... they may recover from that other authority any reasonable expenses.
I was going to say, why would a local authority take over under section 22?
That's the answer.
And that's the answer.
The answer is because they're going to have to pay for it anyway, so it's better for them to be in control of it. And even if they don't take over responsibility, they're still going to be responsible for paying. I mean, I think the reality is that they normally do take over, but whether or not they do in a sense doesn't matter, because it's what we're ultimately concerned
They're liable either way.
Yeah, ultimately what these cases are about is who pays, not who does the work. So that's the base. That's how ordinary residence comes in the Children Act, and then you go to section 105 interpretation, which is quite a long section, as interpretation sections often are. But if we go straight through to subsection 6, which is on page 50, these authorities, you've got your deeming provision, or as I think Mr. Parkhill would insist, your disregard provision. But it comes.
Which page?
I'm so sorry. Page 50.
Page 50, yeah.
Do you see subsection 6? Sort of just below half, sort of 2/3-ish.
Oh, yeah, right, yeah.
Yep. In determining the ordinary residence of a child for any purpose of this Act, there shall be disregarded any period in which he lives in any place, ... C, while he is being provided with accommodation by or on behalf of a local authority. So effectively, as soon as the child is provided with accommodation, that again their ordinary residence is fixed, because from that moment on you disregard any accommodation they're provided with by the local authority itself. So again, if Camden placed the child in Islington or whatever it is, you ignore that and you go back to where they're ordinarily resident.
Would subsection A, institution, cover a care home?
Yes, but it's not always done in it. I mean, that's another way of guessing.
Yeah,
I think that might be right on reflection, but I think C is the more general, my lady, because it's
I understand.
Any accommodation by a local authority.
Anyway, institution is not defined.
I don't think so. It may be, and if it's important for the setup. But I think, the general.
You don't have any children in care homes, do you?
No. Well,
Well, anyway.
No, but I mean,
rightly points
in
out.
any event, any accommodation. I mean, I think for the purpose of the argument I make, I mean, that's the only point. So, albeit by a slightly different drafting technique, you get the same result. And can I again just ask the court to note what is being done here, albeit by a particular drafting technique, is you're fixing the point in time at which ordinary residence is determined, and you're doing so for that obvious policy reason that it's undesirable that responsibility should shift just because an authority places someone out of its own area, because that would have obvious undesirable consequences, as is commented on in Cornwall, which we'll get to.
Yeah.
That's the Children Act. Then we should look at the Carr Act briefly. I mean, the Carr Act is not in play in Cornwall, and it's not in play in this case, but since it's taken over from the National Assistance Act, I think it's helpful just to see briefly that it follows the same model. Now, the primary duties to provide accommodation under the Carr Act are under Section 18 and 19, which we don't have in the bundle. I've brought them along in case, but I don't want to refer you to them unless you think it's useful to see how they work.
Well, let's look at what we've got.
Yes. But then what we've got is Section 39, which is the important bit because it's equivalent to the ordinary residence bit. So 39.1, where an adult has needs for care and support which can be met only if the adult is living in accommodation of a type specified in regulations, and the adult is living in accommodation of a type so specified, the adult is to be treated for the purposes of this part as ordinarily resident in the area in which the adult was ordinarily resident immediately before the adult began to live in accommodation of type specified. There are such regulations. They specify various types of accommodation. We don't have those in the bundle, but this is only to see the kind of broad way it works.
Yeah.
You can see it's the same point again. Slightly different drafting technique again, but exactly the same result. You're fixing a point in time. And my lord, that then allows me to come to the Mental Health Act itself, which is what we're dealing with here. And I not necessarily going to give my lords a direct answer to my lord's question about the change immediately, but we can start perhaps to engage with that issue. So if we can start with the older version of the original version of the Mental Health Act,
Yeah.
that's in tab 3.
Yeah.
So this was in force immediately before the Carr Act changes.
So before 1st of April 2015, is that right?
Up to 31st of March 2015, that's right, yes. And
March or April? March.
sorry, yes.
It goes to
before
the
1st of April.
March and then 1st of April. the
Yeah.
new one.
So up to 31st March before 1st of April, yeah. And materially, at least for the bits we're looking at, this would have been the same right back to the start of the Mental Health Act. Now, I'll skip over for now subsections 1 and 2, though they're quite important because we might as well look at those in the up-to-date version of the legislation. But subsection 1, in a nutshell, tells you when the section applies, and subsection 2 tells you what the duty is and how you bring it to an end. We'll come back to that. But subsection 3, we have to skip over the various 2Bs and 2Cs and so forth, it's over the page. Subsection 3, as it used to stand and as it stood at the time of Hertfordshire, provided, I should say, in this section, the CCG or local health board means the CCG or local health board, and the local social services authority means the local social services authority. Funny. And then for the area in which the person concerned is resident, or to which he is sent on discharge by the hospital in which he was detained. So at this stage, this statute did not use the concept of ordinary residence. And this statute instead used this concept of just pure residence, as it were. And there were various problems thrown up by this, which were resolved in cases which are now no longer of effect. But for example, there's a question mark because what's the effect of the word "or"? Are these just two alternatives, or is one prior to the other? That's one question that arose. What is meant by resident? What does resident mean? Where you're resident in your mental health hospital, or does it mean where you were resident before, and so forth. None of those were answered by the words of the statute, but they were considered in various case law. And in any event, there's this basic problem about it doesn't use the concept of ordinary residence. Now that, as I say, threw up various problems in the case law, and that led to some calls for change. And for my purposes, and I don't want to over-egg the importance of these, but I do say there are some significance. It's worth just looking briefly, at least, at the policy background to the changes. So if we can...
Just before you go on to
Of course, my lord, yes.
This section 1173, as it appears on page 31.
Yes.
That's
the old one.
That's the old one.
We've just been looking at. Yeah.
That was the law as at the time of the first discharge.
It was. Yes. Yes. Yes, it was.
And so, what's the effect of that?
In my submission, none. I don't. So that meant that the responsibility for services at the time of the first discharge, but not at the time of the second discharge,
No.
That's what we're concerned with, but at the time of the first discharge, was, as my lord astutely recognises, determined by this older version of the legislation. Now, on the facts, I don't see that it could have possibly made any difference, because everyone agrees that it was Worcester. She was living in Worcestershire. That's why Worcestershire were responsible, and that would have been plainly the same result if it had been a question of ordinary residence. When we get to Cornwall, I'll show you. I mean, it might be easier to answer my lord's question when we get to Cornwall.
Yes,
and
fine.
I'll show you how.
No, you
Okay,
take
but
it, of course.
I mean, my short answer is I don't accept that it makes a difference, and I don't, in fairness, understand Mr. Parkhill to suggest otherwise. But because what matters is that what matters for the purposes of what we're considering is that at the critical time we're concerned with, which is just before which is immediately before the second detention, she is placed by Worcestershire pursuant to its statutory duty. Now, exactly how that statutory duty came to be allocated doesn't, I suggest, matter. Basically, that's the short answer. So, does that answer that question at least for now? And I'll
Well, I understand what you're saying.
yeah, sure. I mean, you may not be. I don't mean you're necessarily happy with it, but
no. I'm asked in the spirit of genuine inquiry.
No, quite. Yeah. I mean, my answer is it doesn't matter, and I don't think there's a contrary submission.
No.
Yeah. Yeah. So if we can just briefly then turn up the Law Commission, etc. papers. So tab 15 is the Law Commission paper, Adult Social Care. And I don't think that the detail of this matters, but we've just given you the extract which deals with the approach to ordinary residence and the problems thrown up by the different test in section 117 as it then stood. So the court will see there's a discussion which starts on the first page of the extract, the second page of the tab, so page 235.
Yeah.
There's a heading ordinary residence. This is all in the context of the Mental Health Act now.
Yeah.
There's a discussion which I won't read out, which is quite lengthy, paragraphs 11.83 right through to 11.92. But the broad thrust of it is the use of this different approach in the Mental Health Act does throw up problems and anomalies. And that leads to the Law Commission recommendation 63, which is on page 237. The concept of ordinary residence, it's the first part of the recommendation. The concept of ordinary residence should be extended to apply to aftercare services provided under section 117 of the Mental Health Act.
And the word extended, you say, demonstrates it's part of a family. If you see what I mean, it's not
Yes, I do say that. Yes,
from being used in other legislation.
Yes.
Extended to this
legislation. I mean, a word that could have, it's not the word that's used, but it's aligning the approach under the recommendation is to align the approach under the Mental Health Act to the approach that is adopted in the range of other community care statutes.
Well, there are a number of points about that. Firstly, we've only got this one extract. the recommendation talks about extending the concept of ordinary residence.
Yes.
Of course, by this stage, Hertfordshire had been decided, and Hertfordshire is very clear that residence and ordinary residence, there was no difference.
Yes.
So-
Can I just double check that your lordship may well be right that Hertfordshire was decided, but I'm actually not. Can I just double check the dates? Because
Well, I am right, because they talk about it at paragraph 11.87.
You're right. Yeah, you are right. Thank you.
So they're talking about the concept of ordinary residence.
Yes.
But the case law had said there was no difference in the words. That's the first.
No.
In Hertfordshire, they had said there's no difference between resident and ordinarily resident.
No, I don't accept that. They said
Well, we'll
come to Hertfordshire.
come to it. But at 11.88, the consultees are clear. Some don't like Hertfordshire, some do.
Oh, sure. Yeah, absolutely. No doubt.
And so the point then is, well, what happens to how do they square that circle?
Well, I mean,
We're not
it's
here to make legislation.
Oh no, I've got absolutely.
So it's a question of what then the legislation does
Yes.
in consequence of this.
Yes.
But,
Well, the consequence.
the concept of ordinary residence, certainly as being significantly different as a matter of law to residence, would need to be fully explained. It's not here in this short.
Well, there's other part. I mean, I haven't. Maybe we should give you the other parts of the consultation paper. But I seem to remember that there are other parts of the consultation paper which do discuss.
Well, maybe, but this is always the trouble when
Sure.
one is looking at the materials, because
Yes.
ultimately what we care about is what changes were actually made.
Yeah. Well, we'll see that the change that was made was the very thing that's recommended, namely to replace residence as the governing concept with ordinary residence as the governing concept.
Yes. But whether that has any significant legal effect at all is another question.
Well, all that I'm showing you here, so obviously there's a range of views expressed in the consultation responses, no doubt. But of course, the Law Commission aren't bound by the fact that there are differing opinions. I mean,
Of course not.
Law Commission can reach their own view, and they do, because they say, well, actually, it is valuable to align the two. That's why we think you should bring in ordinary residence.
Line. They don't say that.
Well, extend or align.
They say the concept of ordinary residence should be extended. Fine.
Yes.
So we then have to decide how the Act does that, and whether in fact that makes any difference. Which goes back to
of course,
goes back to the point I started with. Why is this? As you can tell, my own view is that this is the point in this appeal, on the first ground.
Yes.
In this appeal.
Yeah, well, my lord, I'm going to come to Hertfordshire. I mean, I don't want to overstate the importance of this document, certainly by itself, because obviously it's just a background policy document. I mean, I can't tell you. But it's part of the overall picture.
Yeah.
And all that I'm seeking to draw your attention to, and I say it's reflected in the couple of other documents I'm going to go to now as well, is that there's a recognition here that the use of residence as opposed to ordinary residence in the Mental Health Act is anomalous and can throw up problems, and that it's desirable that align, extend, okay, well, the word they use is extend, but they're using it in the sense of, we've got this concept of ordinary residence, which is very well established in all of the other statutes, and I've just shown you that, show you examples of that. And it's sensible for that same concept to be extended into the mental health legislation. And that is of some value, I suggest, in thinking about whether Parliament intended a change. And the submission I make, or that I will come on to make, is that effectively when whatever ordinary residence means in one of these contexts, whether it be the National Assistance Act or the Children Act. It's the same basic concept in the Mental Health Act now that it's been introduced there. Whereas what Hertfordshire decided, and we'll come to look at Hertfordshire very shortly, I do promise, what Hertfordshire decided is that it wasn't the same concept. The residents, pure...
So this all turns on the introduction of the word ordinarily.
Yes. Well, in some sense, yes. I mean, I think I'd accept that. It was a significant change.
Well, your case is...
Well, that's my submission, obviously, but...
Yeah. So it all turns on the amendment by adding the word ordinarily.
Yeah. Yeah, I mean, that's one way. Yeah.
So where do we go now?
So the same point, I can just to complete this part of the picture, and then we can go to the amended section 117. So with the next document we've got, tab 16 is the government response to the Law Commission paper. And you can see that it's in pretty short form. If you go to 292 in the authority, so tab 16,
Yeah.
go straight on to page 292. They set out, third box down, recommendation 63, which I've just read to you. So that's just the recommendation we've seen.
Yeah.
And over the page, 11.29, we support the recommend. We similarly support the Law Commission recommendation.
Yeah. The point
So
at 11.29 doesn't address your point that this is fixing responsibility in time before they go into accommodation.
I don't want to...
The point that the government say the reason they give for supporting is a completely different point about, as it were, sort of mixed needs, mixed support.
Yes, but there is that's true, but there's a recognition that the general problem is one of anomalies because you're using different concepts. The point about fixing in time, that comes from the precise way they do it, and we'll come on to that in just a moment when we look at the statute itself. Anyway, that's the government response. And then just for completeness, there's the...
Sorry, recognition of problem of anomalies in...
In that, if you've got different concepts which are used to allocate responsibility, you can end up with a situation which is anomalous in that one authority is responsible for one aspect of the individual's care, and another one, under section 117 as it may be, and another authority is responsible for another aspect. That's the problem with anomalies.
Which is what the government response says.
Which is what the government response says. Yeah, absolutely. And then my lords and my lady, just for completeness, this is actually set out in terms in my skeleton. Paragraph 448 to the explanatory notes to the Act, which is the explanatory notes are at tab 17. Paragraph 448 is at page 346, and over the page. This is in the context of section 75 of the Care Act, which is the thing that amends.
Yeah.
Yeah. And it's 448. And it's effectively the same point. So.
Yeah.
But again, I just that takes it on very slowly. Second sentence here. They apply consistent aftercare ordinary residence rules. So there's an idea of having a consistent set of principles to allocate responsibility. And then the last bit is about introducing a dispute mechanism, so that's a different point. So that's what then leads to the amendment of section 1.
I enjoy seeing all the proclamations of consistency and clarity, but then in the same breath, and another thing, there'll be a ready way of resolving disputes.
Yes, I mean it's undoubtedly
every time.
My lady, yeah. I mean, there is definitely an irony. I mean, you'd think that the notion of where someone lives ought to be pretty simple to resolve, but I've done, I made a career out of doing cases about it. So. There we are. So then we just come to section 117.
As amended.
As amended, sorry, exactly. So that's tab 2. So in tab 2, again, this is just to give you the background. The court will have appreciated that there are a whole range of duties, a whole range of powers to detain people under the Mental Health Act, of which, as it were, the paradigm are sections 2 and 3. Section 2 is admission for assessment, so it's short term. Section 3 is admission for treatment, but there are a whole range of other such powers, including in relation to people in prison and so forth. We haven't obviously put all of those in. But the common provision which relates to entitlement on discharge is section 117. That's page 23 now of the authorities. Aftercare. Now, I'll take this ever so slightly more slowly because we should just look a little bit more carefully in subsections 1 and 2 now because they're relevant to the other ground of appeal. So we can look at them while we're here. So, subsection 1, this section applies. So this is, if you like, the conditions for entry into entitlement. This section applies to persons who are detained under section 3 above and then or admitted to hospital or etc., under various other powers. And so sort of skip over all of those and then pick it up and then cease to be detained and whether or not immediately after so ceasing leave hospital. So the section applies where you are detained, you cease to be detained, and you leave hospital. If those things apply to you, then the section applies to you. Subsection 2 is the duty, first of all. It shall be the duty of the CCG and the authority, the local authority, in cooperation with voluntary agencies, to provide aftercare services for any person. So that's the duty. But then also in this subsection, this subsection also tells you when the duty ceases to apply, because it applies, now I'm sort of picking it up halfway through, it applies until such time as the CCG and the local, etc., are satisfied that the person concerned is no longer in need of such services. So that's the thing so that's how you get discharged, is that the authorities have to get together and reach a conscious decision that you don't actually need the services anymore because presumably your condition's improved or something of that kind. So that's a duty in the way it comes into being and the way it terminates. And then we've now got an amended section 3 over the page 24. So, in this section, and then we've got the same words we've got to come skip over. The CCG and the health board and the local social services means the local social services authority, A, and that's what we're concerned with, if immediately before being detained, the person concerned was ordinary resident for the area in England in which he was ordinary resident. Slightly awkward phrasing, but you can see what it's doing. So it's saying...
Well, it's the same wording for England and Wales.
Yeah, and then you get the same wording for Wales. Yeah. And then there's a sort of catch-all in C, which is if you're not ordinary, which applies if you're not ordinarily resident. So that does two things then. First of all, as foreshadowed in the consultation, etc. documents we've just seen, explanatory notes, it introduces ordinary residence as the governing concept, quite deliberately. Secondly, and importantly in my submission, it fixes the point in time at which you have to determine ordinary residence. Now you can see why, for a person who's detained under the Mental Health Act, you don't want to fix their ordinary residence at the point in time before discharge, because that would mean that first of all that could mean they could be, well, it could create lots of problems. First of all, it could mean that they're ordinarily resident in the area they've been detained, which could be anywhere in the country and not somewhere they have a local connection with. And secondly, there is actually a conceptual problem, because as we'll see from Shah, there's a question mark about whether people can have ordinary residence in a place of detention, so you kind of get into all sorts of paradoxes. So it deliberately fixes it at an earlier point in time, namely the point in time where they're ordinarily resident immediately before being detained. But that has another consequence, because what you don't find in section 117, unlike all of the other statutory schemes that we've looked at, is a deeming provision. But of course, you don't need a deeming provision in a case where the statute, albeit by a different technique, fixes the point in time in this other way. Now that in my submission is very important, because if we think back to the policy problem, the Camden-Islington problem, so Camden places you in Islington and then thereby devolves itself of gets rid of its responsibility, that's addressed in those other statutes by the deeming provision route, broadly. That's not necessary here, because if I'm resident in Camden, I'm detained under the Mental Health Act, I might be sent somewhere else in the country, it doesn't really matter, I'm then discharged. This provision fixes Camden with responsibility for my aftercare. Camden can do what it likes, it can place me in Islington or Westminster or wherever, but it won't change the responsibility because the responsibility is fixed by reference to that one specific point in time. So, albeit by a different route, which is not a deeming provision, strictly speaking, it doesn't require you to treat something as true which isn't true, which is what a deeming provision does. You're achieving the same policy aim of ensuring that placements in other areas don't change the responsibility, or don't change the identity of the responsible authority.
So say that again, by ensuring that...
So because responsibility...
Achieving the same policy aim, by ensuring that...
By ensuring that placements, that placements out of area don't alter the identity of the responsible authority. Which is exactly what the deeming provisions are doing in, for example, section 24.5 is doing. It's saying, once Camden are responsible for you, the fact that Camden place you somewhere else doesn't stop Camden from being responsible for you. Well, this achieves that exact same aim, but by a different route, by a slightly different drafting, effectively by a different drafting technique.
So let's apply that to this case.
Yeah.
You no longer pursue, as I understand it, the submission that this would work by going back to the period of
the first detention.
The first detention.
Yeah, that's correct.
So it's the second detention.
Yes.
So that's fixing the point in time. Let's call it May 2015.
Yeah.
You consider the question, well, where was she ordinarily resident?
Yes. Yeah.
She was ordinarily resident in Swindon.
Well, that subject. But then we need to look at Cornwall. I mean, that would have, but for Cornwall, that would have been a plausible, if not to say correct, answer. But we'll look at. I'll come to Cornwall in a minute. But for Cornwall in the Supreme Court, because that's effectively what the Court of Appeal said in Cornwall, in a equivalent context. But just to deal with the point I'm presently making, can I make that in a slightly different way, my lord? In this case, she's living in Worcestershire before the first detention.
Yeah.
Worcestershire, therefore, were responsible on her at the time of her discharge from the first detention. As it happens, Worcestershire placed her in Swindon, but that placement didn't affect Worcestershire's responsibility. Now, that's exactly what is achieved in the National Assistance Act context by way of a deeming provision. So, but for...
Yeah, we don't have that. That's the point. We don't have the deeming provision here. So here, adopting your submissions, we have a straightforward fixing of time. I understand that. You fix the time immediately before the period of detention. you accept that in this case that would be immediately before the second period of detention.
My Lord,
But for Cornwall, on the second period of detention, she was ordinarily resident in Swindon.
yeah, but for Cornwall, that's right.
Yeah. So that would be different under the National Assistance Act because, or potentially different, because of the deeming provision.
My Lord,
But we don't have that, so we don't need to worry about that.
No. The point I'm seeking to make at the moment, I'm going to have to come to Cornwall and various authorities. Well, the only point I'm seeking to make at the moment is that forget about second detention and so forth. That's more complicated. Obviously, we need to not forget about it because it's this case. But just for this stage of the argument, forget about that for a minute. And forget about complicated situations like Cornwall where you switch from one statutory regime to the other and so forth. Just take the basic way these statutes are all expected to work.
Yeah.
And all of them are the same in this respect. The point is that all of them, one way or another, seek to achieve a situation where once a particular authority is fixed with responsibility because of ordinary residence, the fact that that authority places you out of its own area doesn't divest it of that responsibility. So in the National Assistance...
Sorry.
Yes, I'm so sorry. Does my lady have...
Sorry.
That's right. So in the National Assistance Act, that's achieved by the deeming provision, which says that once you, Camden, have taken someone on, you treat them as living in Camden even though they've placed them in Islington. In the Children Act, it's achieved by the disregard provision, which says once Camden have taken on the responsibility, you disregard any accommodation which Camden itself provides.
That's an example of deeming being achieved by a different route.
Yes, exactly.
It's
because they're
an
not
example of what you say is going on here.
Yes, and in the Mental Health Act, it's not achieved by a deeming provision, and it's not achieved by a disregard provision. It's achieved by subsection 3A, which tells you that for all time you fix responsibility by reference to the moment before detention.
I'm really sorry. You've just used the term "for all time."
Yes. Well, for all time until I mean, that begs the question of what you do on a second detention. I completely appreciate. But for all time, for all time, for so long as the duty subsists, so long as
yeah,
for so long as the original.
But that's what this case is about.
Sure.
Does
absolutely?
The Mental Health Act, as amended, simply says immediately before being detained.
I accept that, my lord, and I'm not saying that this is in itself the answer to the case. What I'm seeking to establish, though, is that, because we're going to, I keep saying this, but we're going to have to come to Cornwall and think about Cornwall and what it does. What I'm seeking to establish is that there is a common thread running through all of these statutory regimes, which is that, albeit by slightly different drafting techniques, they're seeking to ensure that placements out of borough don't, in and of themselves, change the responsibility. And it doesn't matter what and I say it shouldn't matter what the specific drafting technique which achieves that is, when one thinks about whether Cornwall applies in this or that other context. But
yeah, well, we have that.
You've got. I don't want to labour the point too much, but
sounds like we ought to come to Cornwall.
Well, I'm sort of umming and ahhing about whether the next point is to go to Cornwall or to Hertfordshire. I think maybe I'll go to Hertfordshire next because I know that my Lord Justice is very concerned with Hertfordshire, and then I'll deal with Shire and Cornwall, which are the only other two authorities I want to look at. But Hertfordshire is in a slightly different line, so let's take that first and see what it decides, because that's obviously going to be very important.
I mean, what they say may be important, and you'll take us to it, but is this right? You agree that if we were not persuaded that the amendments to the 1983 Act had the effect that you contend for, then Hertfordshire would effectively lead us to conclude that the answer is Swindon.
Well,
because it
Can I see if I can, rather than give a yes?
binding. I mean,
Yeah.
the judge didn't make this point, but
Yeah.
Hertfordshire is binding unless the changes are significant. Of course, if they are significant, then it isn't.
Yeah. Well, I mean, the way I think, I don't want to. Can I try and formulate it slightly in my own words, if my lord doesn't mind? What I said plainly at the time of Hertfordshire, I would not be submitting if those provisions were still in place, and if Cornwall hadn't been decided, I would not be submitting to you that the relevant place of responsibility was still a possible suspicion. There are two key developments since Hertfordshire, and you have to take them together. The first is that the statute is amended, which I do say, and I'll show you exactly why I say this in just a moment, but just so you've got the headline, I do say affects a fundamental change to what Hertfordshire decided. And the second is the Supreme Court's decision in Cornwall, which, albeit, of course, we think it declares the law and it's the law that always existed, was generally understood to affect a pretty fundamental change in the way that ordinary residence was to be determined. Albeit it was always the law. But.
Well, we'll come to Cornwall.
So those are the two strands.
Cornwall expressly approves Hertfordshire.
It does.
So
Yes. Yes, it does.
That's not a reason for
It does.
us to depart from it.
It does, but it's looking at the Cornwall in the. I mean, at that point, the Carr Act. It's not looking at the Carr Act amendments to Section 117.
Well, that takes you back to your first point.
Well, yeah, sure. So let's go to Hertfordshire, if that's all right. So, my lord, Hertfordshire is. Sorry,
Tab 9, yeah.
I'm grateful. Thank you. My notes. We've gone way off my notes. So. So
Well, I hope
Hertfordshire.
we're not taking you.
No. I mean, that's.
Course,
It's entirely helpful to have a debate and to have an interchange. So I make no complaints.
So far, I think we've demonstrated that we understand at least some of the issues. But
You seem to me to understand the issues very well. But I want to see if I can.
You will find we'll get to the edges of that at some point.
Yeah.
But at all events, we've got Hertfordshire, tab 9.
Correct.
I just had, this is a genuine question of information. It's all about...
It's a very confusing case, if that helps.
It's all about some length of stay at Roanu House.
Yeah, it's
being
really
key.
confusing.
Where is Roanu House?
It's in Sutton. No, it's in Sutton.
So how did Hertfordshire get landed with this in the first
It's a totally confusing case. And the answer, and I remember working this out and then forgetting it and working it out again this morning, so I'm very glad you asked me. I mean, the answer so far as we can get it, can I just suggest you read paragraphs 2 and 3 of the judgment, and then I'll add something to it, but it may make a bit more sense.
Nominally.
Because actually the facts that they're looking in Roanu House are not about Hertfordshire is not involved in that case at all. There are two cases, which is one of the reasons, and it's the case is by the time it gets to the court, it's academic.
So even though Roanu House is in Sutton,
Yeah.
the period of stay there was important.
No, hold on. It's even more confusing. So the point that's being made in paragraph 2, there are actually two cases. Before Linden J, at first instance, there were two cases. One was a dispute between Hertfordshire and Hammersmith, and that was about a patient called M.W., who you can see referenced in the middle of the paragraph.
Yeah.
And the other is a dispute between Sutton and Hammersmith, so nothing to do with Hertfordshire.
Right.
And that's about the patient J.M.
Right.
And the facts, for some reason, which I don't fully understand, but I don't think we need to or should try to get to the bottom of it, the facts of J.M.'s, when it talks about the facts, J.M.'s case, paragraph 6 through to 12, he's actually talking about the facts of the Sutton-Hammersmith case, not the Hertfordshire case at all. So that's why you will search in vain in those paragraphs for reference to anywhere in Hertfordshire.
Okay.
So that's why it's a really odd case. And what's also really odd is that I don't know about in the first instance, but by the time it gets to the Court of Appeal, the live issue is a very abstract issue, which is that what Hertfordshire, who decided to continue with the case, even though they've resolved the case on its facts, there's no live dispute of fact, they're seeking a declaration as to the law. And we'll get to the precise form of the declaration that they were seeking in a minute, because I'll show you the relevant paragraph. But in a nutshell, what they're seeking is a declaration that the concept of residence in the Mental Health Act is the same as the concept of ordinary residence in various other statutes. And the court refuses that declaration in effect. So, as I say, it's a jolly confusing case. And it's a bit unclear what it... I mean, it does decide something important, actually. I'll show you that in a minute. But it's quite what it decides is rather an abstract point, the kind of thing that courts often tell people they're not prepared to decide at all. So you can see paragraph 5, for example. Against this unusual background, we've been asked to consider the facts of JM's case, that's the Sutton case, remember, as illustrative of the problem, even though the case is not strictly before us on the appeal. No substantive relief is sought by Hertfordshire other than a declaration designed to settle the legal position for the future. And so that's why I think trying to work out what's going on with the facts or anything is not going to be very productive in this case.
Right.
So, we can then, I'm not, for obvious reasons, I'm not going to take you through the judgment in detail, but the important bit for our purposes is page 170 of this bundle, page 1636 of the report, in the judgment of Lord Justice Carnworth, as he then was.
I'm just regrouping. Section 24 says in towns ordinary resident, and section 117
at the time
didn't. Yeah.
At the time,
yep,
didn't.
Understood.
Yeah,
yes.
That's right. Correct.
So they say paragraphs.
Correct. So 1636 of the report, heading discussion. Lord Justice Carnworth says he's got considerable sympathy for Hertfordshire's arguments and so forth. And then paragraph 45.
And Hertfordshire's arguments being?
Well, so you can see that in paragraph 46. So Mr. Green is for Hertfordshire.
Yeah.
Paragraph 46. Those considerations are sufficient in my view to require us to reject Mr. Green's proposed form of declaration. That invites us to hold that, so this is the declaration that's being sought, is resident in section 1173, has the same or substantially the same meaning as ordinarily resident in section 24 of the 1948 Act. That is inviting us to rewrite the language of the statute to the form which Parliament could have adopted but did not. It glosses over the status of the deeming provision, reinforced by the contrast with the case.
What does that mean? What does it also glosses over the status of the deeming provision. What does that mean?
I don't 100% know, my lady.
I'd assumed that he was meaning by that he couldn't equate the two because
I think
ordinarily resident in the 48 Act is conditioned at least
yes,
in part
I think
by the
right.
deeming provision,
I think
whereas
that's right,
in 1173 it's just
he's saying it's another complexity, effectively.
yeah, another complexity.
Another complexity.
Yeah.
Yeah, that's right. And then there's a discussion.
It's a jolly odd declaration.
Yeah, it's a very well, absolutely. I mean,
because that is asking the court
Yeah.
to rewrite the statute.
well, it's asking,
when you said resident, what you really meant? I mean, that
it's a very odd declaration in that sense, and B, it's a very odd declaration in the sense of being abstract, because it's begging the question about what ordinary residence means. It's not saying what it means. It's just saying whatever it means, residence always means the same thing. So it's a very odd. That's why I say it's a very, very odd case.
I see Lord Justice Jackson granted permission. He wasn't one for granting
No.
permission willy-nilly. But
I mean, I think in fairness, what seems to have happened is that the issues kind of shifted
Narrowed.
around and things
Yeah.
became academic,
Yeah.
and then they decided it was an important case. I mean, it's not for me, it's anyway, to second guess that kind of decision. But it is a very odd case, and it's a pretty confusing case in that sense.
yeah, well, I'm grateful for the help on the facts because I couldn't work.
No, well, I don't mind admitting that I had a bit of a panic about it this morning.
I thought maybe there was another Sutton in Hertfordshire. That's in the end how I squared circles. I was wrong.
I'm not very good at English geography, and I did have a moment when I was trying to remember if Hertfordshire is after all south of London. Anyway, there we are.
Okay. All right. Well, so you've shown us 46. We understand that. Yeah.
I mean, you should probably just read. I took you to 46 because it's quite important to see the declaration, but probably just read 45, which is to the Can I just ask you to read 45?
Yeah.
And then there's, I mean, I think that's all we really need. I'll see what my learned friend says about it, but at the moment, that's all I think we really need. So the only holding in Hertfordshire is that the phrase resident in the then version of section 117 is not the same concept as ordinary residence in, for example, section 24 of the 1948 Act. Now that of course is binding on you, no question about that, and it's not disapproved. It's approved or not disapproved in Cornwall, so it remains good for what it decides. Completely accept that, but with respect, it can't be binding, or it can't be, in my submission, it's not relevant to the question which now arises, which is whether the amended section 117, which now does deliberately use the phrase ordinary residence, with, as we've seen, the deliberate intention to extend the concept which is used in those other statutes to the Mental Health Act, that they have a different meaning, or that they don't have the same meaning, because that's just a different question. The whole reason that Lord Justice Cornwall says they're not the same thing is because Parliament has used deliberately different language. Whereas now Parliament has used deliberately the same language.
Well, that, to use the expression of this, glosses over a number of things, including the deeming provision. You say, well, that's provided in another way.
Yes.
And we'll have to consider.
I don't say that Hertfordshire is, as I say, that's why I say there are the two strands. Hertfordshire can't be the whole answer to my case. I don't say because, but insofar as the judge, I think, did rely on Hertfordshire, and I think my learned friend relies on Hertfordshire. The reason that Hertfordshire can't be the answer to can't be the if you like the creators to my case, is because the whole ratio of Hertfordshire is if Parliament uses different language, it must be presumed to have intended a different result, at least in some situations. Whereas we've now got the same language. So what Hertfordshire?
Well, I mean, the difficulty is that somebody called Mr. Green was inviting the court to make a pretty bold declaration, and the court rejected that invitation.
Yes.
And as I read it, you'll tell me I'm wrong, but one significant issue for the court in Hertfordshire, which I'm now going to call Hammersmith and Fulham.
Yes.
That seems to be a much better title for it.
Sutton even.
Well, Hammersmith and Fulham at least is a
they're at least a party. They're a party to both cases.
Yes, quite. The issue that troubled the court was if you say, it ordinarily resident, well, using the Shah definition, you'd have to exclude detention. And at the time we're talking about, the provisions to which you directed us didn't apply, and there may be great difficulties.
No. Actually, I mean, one of the things that I don't know if it's reflected in this, but I think it will be common ground. I think it was Mr. Justice Scott Baker in an earlier case had said you do exclude detention.
Fox and Stirk.
Yeah, Fox. That's right. No, I don't think it's. I think that's an earlier.
Fox and Stirk?
I don't think he is Fox and Stirk, but anyway, there is an earlier case.
Scott Baker referred to it. Yes.
Yes. Anyway, there is
Here we are.
Yes, that's it. So there is an earlier case in which I think it's Mr. Justice Scott Baker decided that when you're deciding residence under the old version of Section 117, you go back to residence before detention. So the thing that we've now got expressly in Section 117, immediately before detention, had been held to be implicit in the old version of Section 117. I'm not sure if that's...
Well, anyway, the issue, the problem is Hammersmith and Fulham simply decided that a declaration that they wanted simply wasn't appropriate because then it would rewrite the statute.
Rewrite the statute.
With,
Well,
you know, with who knows what effect.
Yes. I mean, it's obviously, by the way, it obviously is the case that there will be a significant number of cases when the residence test in the old Section 117 will produce the same result as the ordinary residence test in the other statutes. I mean, they don't always produce a different result, but they're not. What all that this case is deciding is that they are not, for all purposes, the same thing. That's why the declaration is rejected. And that's. I'm not suggesting that was wrong at all. My submission is absolutely right.
But the issue had arisen because that qualification was, because it was resident, word was resident, was effectively being ignored, which is why in the Hertfordshire dispute, and that's why Hertfordshire were pursuing it, they got landed with the cost.
Yeah, I think that's right. I can't remember.
I mean, that's why Hertfordshire were pursuing the cost.
Yes, we don't. One of the slightly troubling things is because we don't have the facts of the Hertfordshire case actually set out in the judgment. So we've only got the Sutton case facts set out in the judgment. It's quite difficult to work out exactly what Hertfordshire were concerned about.
But that's why they were pursuing it. Because,
yes.
I mean, you know, we can work that much out.
Yeah.
They had got landed with a bill
for sure.
for somebody who wasn't their resident.
For sure.
And
who'd been I think they'd been landed with the cost for somebody who'd been placed in their airbase.
And the same was, I think, true of Sutton.
Yeah.
Because at first instance, Mr. Justice Mitting said, the question would be, where do you live? And if he was asked, he'd say, well, I live in Sutton, but I'd much rather be living in Hammersmith than Cornwall.
But that wasn't good enough to change. Yeah, that's right.
So that I mean, we can't lose. Obviously, the claim for the declaration failed, but we can't lose sight of the reason why that was all in issue was because they had hoped that if they got the declaration, that would be a step towards
that's right.
them
That's clearly right. But I mean, the point that my Lord Justice Coulson raised with me earlier is, well, aren't we bound by Hertfordshire? Well, you are bound by Hertfordshire for what it decides, but all that it decides is this rather abstract point about the declaration, i.e., are resident and ordinary resident the same thing? Well, no, they're not. And that has no relevance to the question which now arises, which is whether ordinary residents and ordinary
The
residents.
only additional point that you might draw on is the recognition by the court of the policy reasons for reaching a different view.
Yes, although they're also reflected in Cornwall, and we'll see them in Cornwall as well.
I see.
So, but my lady's right. That's absolutely right. So that's Hertfordshire.
Go on, we're going to go to Cornwall.
I'm going to go to Cornwall. I think I ought to just briefly take you to Shah then, although that's relatively uncontroversial and simple, and then we can go to Cornwall, which is where most of the rest of my time I'll spend on. Shah is, forgive me, I've got some notes, but I've lost copy.
6.
Shah is tab 6, thank you. And, I mean, this is the case that's always cited rightly as the legal authority on the basic concept of ordinary residence. The underlying dispute, like all these cases, has some complexities. So the real issue, it's about entitlement to a local authority education grant, as I said. Yeah. The thing that the lower courts have decided was that you couldn't be ordinarily resident if you didn't have effectively a full if you weren't a British resident, effectively. And the House of Lords says no, that's nothing to do with ordinary residence. It's just where you live, effectively.
Yeah.
But in the course of doing that, Lord Scarman gives the classic statement of what ordinary residence means. It's page 343 of the report, 105 of the bundle. And the basic idea is indeed a very simple idea. One sometimes wished that we'd stopped with this case and never got any more, but there we are. And there's a paragraph beginning just below G, unless therefore. So, unless therefore it can be shown the statutory framework, etc., requires a different meaning. He says, I hesitatingly subscribe to the view that ordinarily resident refers to a man's abode in a particular place or country which is adopted voluntarily and for settled purposes as part of the regular order of his life for the time being, whether of short or long duration. So in other words, it's where you're living for the time being. And then there are a couple of exceptions which you should just note. The first is the exception which relates to illegality. and this is the point about where the person is seeking to use ordinary residence to establish an entitlement, it may matter whether they're legally resident. That's the first paragraph, but that's not relevant to us, so I note it and move on. And then there are the two qualifications, so I'm in 344 of the report now, just below, at or just below B. There are two and no more than two respects in which the mind of the propositus is important. The residence must be voluntarily adopted, enforced presence by reason of kidnapping or imprisonment, or a Robinson Crusoe existence on a desert island with no opportunity of escape may be so overwhelming as a factor as to negative the will. And that is why, inter alia, it's normally assumed that you can't get an ordinary residence in the place of detention or imprisonment, for example. And then the other qualification, there must be a degree of settled purpose, maybe one, maybe several, it may be, etc. I won't read down the whole paragraph, but the thrust of that is you've got to be settled purpose. So, for example, if I, as by now you know, if I live in Camden and I go to Birmingham to do a case and I stay overnight, I don't acquire an ordinary residence in Birmingham just because of that. My ordinary residence remains in Camden. I think that's the basic idea.
Yeah. Well, it's the final sentence of that paragraph, isn't
Yes.
it? Purpose of living where one does has
Yes.
a sufficient degree of continuity to be properly described as settled.
Correct. That's right. Yeah. Yeah. So none of that's terribly controversial, but it just seemed to me it was useful for you to see that basic statement. That takes us
that, of course, all of that says and starts with unless it can be shown.
Yes.
The statutory framework has a different meaning. So subject to that, leaving that proviso to one side,
Yeah.
doesn't all of that, in this case, again suggest Swindon?
It does.
Yeah. So you say
But I see.
it does suggest Swindon, but
We need to look
here's
at
the statutory framework. It's
Well,
different.
yes. I mean, what I say is, in a nutshell, is we need to look at Cornwall.
All right. No, that's fine. That's fine. My lord is
Yes,
dying
yeah.
to get to Cornwall.
Yes,
so
I know.
I don't want to interrupt
Well,
any.
it's
I don't want to
Maybe
interrupt
just
any
come.
more.
It's the important case, and it's the case. Look, whatever you think of my arguments, it's a case which has thrown up quite a lot of confusion, and it's we need to.
So it's going to be this case that will finally provide the clarity.
We hope so. We hope so, and the court will appreciate that. My client has no axe to grind. He's taken a position on how you do this, but we're also just quite keen to get the law clearly established. So we'd like you to decide it in the way we invite you to decide it, but we also do want to know what the law is.
Yeah.
So Cornwall is at tab 11.
Yeah.
Now,
I think we're going to be the last.
Cornwall is at tab 11. Can I just then, the background, without reading through vast swathes of the judgment, can I just try and explain the kind of how the issues in Cornwall arise then?
Sorry, I'm just clearing my mental deck.
Yes, of course.
If you're right, Hertfordshire really doesn't matter at all.
Yes.
It's almost irrelevant.
Yeah, I say it's irrelevant because it's about
Okay.
a statute. It's about the wording of a statute which has been amended.
But
In a way that's
you
direct-
then say, but on ordinary principles, ordinarily resident in Swindon immediately before second detention, and that's against you. So
Yes.
now we come to Cornwall
Now
and
we
you
come to
say,
and
this is why actually, right.
Yeah. So it's really ultimately, I say it's about how broadly or narrowly you interpret the passages in Cornwall we're going to look at in a moment. So just to get the context of Cornwall then, this case, it's a similar sort of dispute, lots of local authorities all pointing the finger at each other. It concerns the ordinary residence of a service user, as I think I'm asked to call them now, who's called P in the judgment. He is, in the sort of chronology that we're aware of, he starts as a child living in Wiltshire with his parents. And because he has complex needs, Wiltshire take responsibility for him under the Children Act, under the provisions that we have seen, and provide him with accommodation. So at this stage, no doubt that Wiltshire are responsible for him under the Children Act. Then a number of things happen so as to give rise to the dispute which the Supreme Court ultimately resolved. First of all, Wiltshire then place place him in South Gloucestershire. But of course, at this point, he's still a child. So although he's actually living in South Gloucestershire, by virtue of the disregard in section 105 that I've shown you, Wiltshire retain the responsibility for him, notwithstanding he's actually living in South Gloucestershire. That's the first thing that happens. The next thing that happens, shortly after as it happens, is that his parents then move to Cornwall. And the next thing that happens, and the critical thing in terms of giving rise to a need to look at his ordinary residence again, some years later, is that he turns 18. So when he turns 18, he ceases to be entitled to services under the Children Act. He becomes entitled to services under Section 21 of the National Assistance Act instead. And the question of his ordinary residence arises again. So effectively, the question arises again because he's shifted from he's shifted from one statutory regime to another. Now, again, there's a lot of colour and background to all of that, but those are the key facts that you just need to have in your mind about the case. Excuse me. So there are, in this case, before the Supreme Court, then 3 candidates for the responsible authority. There's also, by the way, Somerset. He later moves to Somerset, and Somerset take involvement in the case, but I've never understood why Somerset could arguably be said to be in the frame, so forget about Somerset. So there are 3 live candidates. The first is Cornwall, the second is Wiltshire, and the third is South Gloucestershire. The case, in a nutshell, as to why each of them might be responsible. Why might Cornwall be responsible? Well, Cornwall might be responsible, it is said, and the Secretary of State actually decided this, because of a decision of Mr. Justice Taylor in the late 90s, I think, early 90s, called Ex Parte Vale.
Ex Parte?
Vale, V-A-L-E. And what Vale, I mean, Vale was, we don't need to look at it, thank God, but what Vale was either decided or at any rate was had been widely understood as having decided is that for a person who lacks capacity, they are to be treated as being ordinarily resident in the area of their parents. Now, there's a real question about whether Vale did actually say that, but in a sense, we don't need to worry about that. But the Secretary of State understood the case in that way. The Secretary of State promulgated guidance saying that's what the case decided, and the Secretary of State, pursuant to his own guidance, decided the dispute between these various authorities on that basis. So that was the case for Cornwall. Now, the Secretary of State then defends the case in the High Court successfully, and so in other words, the Vale approach is upheld. But Vale is then rejected by the Court of Appeal. You say that's completely, either Vale is wrong or it doesn't say that. And Vale is also rejected by the Supreme Court. So the case for Cornwall...
So the Court of Appeal rejected that, and the Court of Appeal said...
Yes.
South Gloucestershire.
They did, and I'll come on to that in just a moment. And, you know, I don't mind admitting I thought the Court of Appeal were right at the time.
To say South Gloucestershire.
Yes, exactly.
And why did they say South Gloucestershire?
In a nutshell, they said it because that's where he was living.
Yeah.
I mean, it's exactly the point my Lord made to me not very long ago about what are the implications of Shah.
Yeah.
Anyway, so Cornwall, so that's Cornwall. Cornwall kind of fall out of the picture for our purposes. We don't need to worry further about that. The remaining candidates then are Wiltshire and South Gloucestershire. And the case for South Gloucestershire is straightforward enough. As at his 18th birthday, that's where he's actually living. So applying Shah, that's where he's ordinarily resident. And importantly, although there are all these deeming provisions in both acts, both of them apply expressly only for the purposes of their own act. So the deeming provision I showed you in 24.5 says, for the purposes of this act, you treat ordinary resident. And there's a similar provision in, I think we saw it in 105.
Sorry, and which were the two acts with the deeming provisions could have been relevant?
So the acts which are relevant to this case are the 1948 Act and the 1989 Act. Yeah. And the deeming provision, the relevant deeming provision, section 24(5) of the 1948 Act and section 105(6).
The one that you showed us earlier.
Yeah, which I've shown. Yeah, exactly. And that's why the reason I showed it to
Strictly
you.
speaking, the disregard provision, but you say
Disregard deeming. Yeah, I mean, I think it gets called a deeming provision in here, which
yes. Well,
but,
let's call it a deeming.
let's call it that. But I mean, yeah, but it's a disregard. You're right.
Yes.
You're
All right.
So,
A means whereby ordinarily resident means something different
yes,
to the words
Yes.
ordinarily resident
Yes.
in the
yes,
English language.
yes. A deeming provision, strictly speaking, is something. It says something is true. You should treat something as being true, even though it's not
Yeah.
true. That's right. And it's right that the section 105 is not strictly a deeming provision.
No,
in that sense.
it's you disregard something which is might otherwise give rise to a
Yeah,
different
yeah,
result.
yeah. But it's a fairly subtle difference, and probably not one we need to worry about.
Yeah.
But yeah, my lord is absolutely right. So that's the background. Now, as my lord,
Sorry, Wiltshire liable because we've done Cornwall, we've done South Gloucestershire.
so Wiltshire, the argument. Well, we'll see why Wiltshire are made liable by the Supreme Court in a moment. But in a nutshell, the argument for Wiltshire is that they retained responsibility under the Children Act. They had placed him in South Gloucestershire. And so notwithstanding that he was actually living in South Gloucestershire, he is to be, his real ordinary residence
So
remained.
Wiltshire is our Worcestershire.
Wiltshire is our Worcestershire. Exactly right, Melanie. Yeah, exactly right.
Sorry.
No, but that's exactly right.
The transcript of this will just look mad. So if it's Hertfordshire, it's Wiltshire, and so on.
Wiltshire is our
I mean,
Worcestershire.
Right, I'm sure it will.
So my lady puts it in a nutshell. So Wiltshire is our Worcestershire.
Yeah, but it is actually. I see that. I hope it's not my fault.
It's not. It's nobody's fault. It's just the way.
It's just the
of
way the
these
argument.
cases.
It's the benefits of an interchange with the court, which. But yeah, these things.
So Wiltshire, because retained responsibility under the Children Act, it had placed P in South
Yeah.
Gloucestershire, but what? I just missed the last bit.
So well, that's it. I mean, we're going to look exactly what Lord Carnwath says. So I'll put a bit more flesh on those bones in a minute. But in a nutshell, it had done the placement.
Yeah.
And my lady is right. Wiltshire is our Worcestershire, and South Gloucestershire is our Swindon. And I think it is helpful, actually. That's actually a very helpful way of putting it. So now we haven't got the Court of Appeal judgment, but in a nutshell, what the Court of Appeal says is...
Well, the judge below set out big chunks.
He did, and I think we had it in the
Justice
authorities
alive,
below.
so
Yeah.
That's fine.
Yeah, that's fine. But in a nutshell, what the Court of Appeal says is, it's not Cornwall, ex parte Vale, that's a load of rubbish. Therefore, where is he actually living? We apply the Shah test. It's where you're actually living. At the relevant time, he's living in South Gloucestershire. There's no relevant deeming provision. That's it. It's South Gloucestershire. That's what the Court of Appeal say. And one can quite see. I mean, it's not for us to say that was right because the Supreme Court has told us it's wrong, but one can at least see the attractions of it, and in a sense, that's encapsulated in the point my lord put to me earlier about the present case. And indeed, and again, it's only a dissent, but that's also for what it's worth what Lord Wilson thought in it. What is undoubtedly a pretty powerful characteristic dissent. But that's not how the Supreme Court approached it. So if we then, with all of that background, go to the judgment. So just to note some of the background bits of the judgment, there's a discussion of ordinary residence beginning at the concept of ordinary residence, beginning at paragraph 33 and running right through to paragraph 48, which I'm not going to read out, but it may be useful to look at it, invite the court to look at it in due course.
Sorry, I was marking up something else. Which section?
So there's a fairly lengthy discussion of the concept of ordinary residence, which the court might just
39 onwards.
33 to 48. And in the course of that discussion, I just note in particular paragraphs 41 and 42 refer to shall, and I think it's clear effectively it's accepting that shall is subject to what the court itself goes on to say in this particular case. Shall remains the broad governing authority. And people will disagree about whether this case overturns shall or applies shall, but I mean I think the Supreme Court thought that it was applying shall for what it's worth, albeit it does seem to modify it quite a lot. And then just for completeness, so the discussion in the present of how to resolve this case begins in paragraph 49, top of the page. It's page 168 of the report, 210 of the bundle. There's a heading, ordinary residence in the present case. And 49 to 51 deal with the Vale case and say why that's not the right approach. So we needn't trouble too much about that, but that's how they deal with it. And then we can pick it up at paragraphs 52, and really, although it's quite a long section, all of paragraphs 50, I'm not going to read all of it out, but all of paragraphs 52 through to 60 are quite important, frankly.
52 to 60.
52 to 60 contain the key part of the judgment. Now, as I say, I won't read all of it out, but can I just invite the court then to pick up a few points? So at the start of 52, you see the way it's framed. So the more difficult issue is to make a principled choice between the two alternatives, South Gloucester or Wiltshire. And then what follows in this paragraph, which I won't read out, is a recognition of the simplicity and attractiveness of what the Court of Appeal had decided. In other words, applying the Shah tests without qualification, it's easy to understand why the Court of Appeal chose the former, and then they go on to expand on that, but we've already discussed the central logic of what it was saying. So you might think, well, why do we get a different result? Paragraph 53. However, although the choice of South Gloucestershire may fit the language of the statute, it runs directly counter to its policy. Now, again, I don't want to read all of this out, but can I first of all invite the court to read paragraphs 54 and 55?
Those were, again, I think, passages which the judge below set out in full.
He did, and if you've read the judgment, you'll have read them, and I don't want, if the court's satisfied it's got the thrust of them.
Just give us a moment.
Yeah, of course.
To remind ourselves. Yeah.
So what that is talking about then is what Lord Carnwall perceives as the policy of both the 1989 Act and the 1948 Act in terms of embodied inter alia in the deeming provisions, in terms of responsibility not sort of shifting around as people moved around the country. That's the basic point. And the reason then that I spent a little bit of time making the points about section 1173 as it now stands.
When he says both acts,
yes,
he's talking about the 1948 Act and the 1989 Act.
He is, yeah. Correct.
Yeah.
Because they're the statute.
They're the two. I understand.
Yeah, yeah.
Okay, so that.
And the Carr Act has not yet come. I think it might have even been. It probably just about got royal assent.
Well, as I understand, it was something Lord Carnwall would have known about, but it wasn't yet law.
It wasn't yet law, and in any event, as these, because cases take a long time to get to the Supreme Court, so obviously they were looking back at a set of facts which are governed by the. I think that if you look at the date of argument, so if you go back just to the first page, the argument is in March 2015, and although the Care Act 2014 is a 2014 statute, it comes into force on the 1st of April 2015.
Yeah.
So
by definition, it was there sitting
it was there, and they say somewhere, and I'm sorry, I'll try and...
Is it referred to anywhere?
They say, and I think they do make a passing reference to it somewhere. Perhaps I'll just try and find you the reference for that. But
I'm sorry to interrupt. Where it says in paragraph 53 of Cornwall,
yeah,
this is the rationale for dumping South Gloucestershire.
Yeah.
The only connection South Gloucestershire had was a historic placement under a statute which specifically excluded it from consideration. That's a reference to section 24 of the 1948 Act.
No, it's no,
that's
because the
the
placement
Children
is
Act.
under the Children Act. Yeah.
Right, so...
Yeah.
Oh, I see, I'm sorry, because
Yeah,
Somerset's the 48 Act.
Yes, there's a later placement in Somerset.
Somerset you can forget, because...
You can forget about Somerset because you only get the placement in Somerset after the 1948 Act kicks in. So Somerset were never in the frame.
Right.
Effectively.
So, and it's excluded from consideration as the place of ordinary residence because of the disregard / deeming provision in the Children Act.
Correct. But of course, it's only excluded for under the deeming provision. It's only excluded for the purposes of the Children Act and not for the purposes of the 1948 Act once that kicks in.
Right, so we've looked at 53 to
Great.
55.
And then, really, what I say, and I think my learned friend may agree with this, what I say, we didn't, for present purposes, read out 56 and 57.
Well, that's dealing with Hertfordshire.
It does, yeah. Yeah, I mean, I don't propose to say anything about it particularly, but I mean, my Lord has already picked up that it certainly doesn't disprove Hertfordshire.
No.
But
Nor would you expect.
But, well, actually, just while we're on it. Yeah, but I'm not sure we get anything further out of it that we haven't already seen. So if we come then to 58 to 60, these are the key provisions.
Sorry, 57, surely. Statutory context is critical.
Yes. Yeah, I mean, a lot of what's in 57 is repeated in 58.
I see, sorry.
I don't want to.
Except I think though that my lady is right to say that 57 is, I think, the first time that Lord Conworth expressly goes back to Shah and say, yes, but that's subject to the proviso of it depending on the, unless the statutory framework suggests a different meaning.
Yes.
Which seems to be his in for what you.
Yeah, I think that's right. For
what you then say is the key bit.
Yes.
Which you say starts at 58, is that right?
58, yeah, and it's 58 to 60. That's right.
And do you want us to read that?
Well, yes, can I invite you to read that? I mean, you'll have almost certainly read it in various skeletons and so forth, but in any event, perhaps just read it again. Or 70. Oh. I think there's some. I'll come back to more. Sorry,
Yeah.
So I'm just seeing if is the court ready for.
Yeah, you carry on.
Thank you. So I mean, you'll see what they say. Big question is what does he mean, or what's the breadth of what he's saying? So, 58, section 24.5 poses the question: which authority's area was PH ordinary? So that first sentence, by the way, is making that point which I have rather, no doubt, harped on or perhaps laboured, which is that what the deeming provision is doing is it's fixing a point in time. It's that same point, effectively.
So which first sentence?
The first sentence of 58.
Yeah.
And he goes on to say, in a case where the person concerned was at the relevant time living in accommodation in which he had been placed by a local authority under the 1989 Act, it would be artificial to ignore the nature of such a placement in that parallel statutory context. He was living for the time being in a place determined, not by his own settled intention, but by the responsible local authority solely for the purpose of fulfilling its statutory duty. Now, I'll come to 59 and 60 in a moment. But in my submission, that encompasses the ratio of the judgment. And what it is saying is that where you are determining ordinary residence for the purposes of a statute which allocates responsibility for payment or provision of community care, you should disregard placements which are made by a local authority solely for the purposes of carrying out their statutory duty in a parallel statutory context. So in this case, that's to say Cornwall, I mean, let me get it right way around. Wiltshire had placed P in South Gloucestershire for the purposes of carrying out its statutory duty, as it happens under the Children Act. And in those circumstances, when you come to decide an ordinary residence under the, as it happens, the 1948 Act, which is a parallel statutory context, you disregard that placement. That's the proposition which I invite you to take from, well, all of these paragraphs, but for example, paragraph 58. And if that's the right, now, that's not, let me acknowledge, that is not an unproblematic reading of the judgment. It's not an, as you've probably gathered, I don't think it's an unproblematic judgment.
Yeah.
And I'm not alone in that.
Why is it not an unproblematic reading?
Well, I don't want to say, I mean, one reason it's, I think in my mind, the fundamental reason it's not an unproblematic reading is that it seems to make the deeming provisions, which each of these statutes had, redundant. That's a point that Lord Wilson in his dissent makes.
Oh, I see what you're saying. Sorry, you're not saying that your interpretation of the...
I mean, it's my interpretation, yes. Sorry, yeah.
You're not saying that your interpretation of the decision is problematic. You're saying that the decision is not without...
Well, sorry, yes, exactly. It's,
okay.
Yes,
Okay.
yeah. I mean, it's... And it has caused lots of... That's why it's probably why it's caused lots of confusion. I mean, we just have to face up to that, and I don't want to... I mean, it's a decision of the Supreme Court.
In terms of what you say it says, you say that's the clear reading.
That's a clear reading, yeah, absolutely.
So that hence, in that case, Wiltshire.
Yeah.
So we translate that to our case.
Yes.
So you say, therefore, that must mean Worcestershire.
Yes.
Because it's artificial.
Yes.
To ignore the fact that JG, is it?
Yes,
so
JG,
yeah. But in this case, JG was placed there by Worcestershire.
Yes, correct. Yeah, exactly right. It's exactly the same.
But so that wasn't a random placement, was it?
No, it wasn't a random placement. It was a placement pursuant to its statutory duty.
Yes, it was pursuant to its statutory duty, but it was Swindon rather than Tyneside, because that's where her daughter lived.
Yeah, well, that's for sure.
But you say that's irrelevant.
But that's irrelevant. I mean,
but it can't be, can it? It can't be entirely irrelevant. I mean, let's just think it through.
Well,
if you're right, because you are, I mean, speaking personally, that one sentence at the end of paragraph 58 didn't necessarily sing out to me as being the ratio of the case.
Sure.
I thought the ratio of the case was the fiscal and administrative.
Well, we'll come to that, and we say.
But anyway, you say this is the ratio, and you, and this is your broad interpretation. I get that.
Yeah.
But the consequences of that could be very significant, because if you're always coming back to the placer, then you could have circumstances where it's clearly in the service user's best interests for him or her to be placed closer to a family member in another part of the country. But the placer thinks, well, I'm going to have to pay for this. I'm not sending them to Kent or wherever it might be, although that's in her interest, because they're so expensive.
Well, look, that's a problem which doesn't arise from this. Though. That arises. So remember, when she's placed in Swindon, in this case, that's got nothing to do with the second detention, and there's no expectation of a second detention at that stage.
Well, I understand that.
So
but I'm just.
So
I mean, if the position was, as you put it, that effectively you always come back to the placer, then the Act could have said that.
Yeah. Well,
the amendment could have said that.
In a sense, so there are a couple of points. The first point is that leaving aside cases of second detention, that is what the Act provides. So just take the facts of this case for a moment, but forget about the second detention. JG was living in Worcestershire before she's detained for the first time. She's detained, she's discharged. As my lord points out, her daughter lives in Swindon.
Yeah.
So everyone thinks, well, it's in her best interest to go to Swindon.
Yeah.
And so she's placed in Swindon. But that doesn't affect Worcestershire's responsibility.
Isn't this the exact policy concern in paragraph 55?
It is,
where the Supreme Court says in terms, well, you know, it'd be wrong if there was something in the way of a responsible authority placing the person in question in the right place here, Swindon. Yes.
Well, for what it's worth, I've not previously. I mean, I'm not saying it's not a concern, but I've not previously encountered the thought. Well, you know, some areas are particularly expensive, so people are unwilling to place them. Well, I mean, there may be something.
My experience. In this that is a point that now does arise. Anyway, your answer, but let's just get your first answer was, well, you say that's what, if you ignore the second detention point,
in most cases that's what happens.
Provides. So, or you said there were 2 points you wanted to make.
I'm going to try and remember what the second one is.
There were 3.
That's right. No, don't worry. It might,
well, let me just
anyway, that is. I understand that that's an answer to the point that I raised with you. All right.
Yes.
So anyway, that's 58, and your submission that last sentence of 58 is the ratio.
Yeah, but it certainly. I mean, 50. Again, let me be just completely frank. 59 paragraph is slightly more problematic for me, and that's the bit that my learned friend says. Is that he says you get the ratio of 59, not 60. I don't accept that it is the ratio, and I also don't accept that it's as problematic as he says. But acknowledging, as I do, that 59 is at least a bit more tricky. Can I just come on to 60 for a moment first? So on this analysis,
can we just look at 59?
By all means,
just explain the point.
Yeah. Well, I mean, it's really for my learned friend to explain, I think. But I'll just deal with it. I'll deal with it briefly. Exactly. Yeah. In other words, so he goes on. In other words, it'd be wrong to interpret Section 24 of the 1948 Act so as to regard PH as having been ordinarily resident in South Gloucestershire by reason of a form of residence. I think this is the bit he relies on, whose legal characteristics are to be found in the provisions of the 1989 Act.
Yeah.
And he goes on, since one of the characteristics of that placement is it did not affect his ordinary residence under the statutory scheme, it would create an unnecessary and avoidable mismatch to treat the placement as having had that effect when it came to the transition as carriage. Yeah. So I think what my learned friend says is that shows that the ratio here is somewhat narrower. Because
that's a reference to the disregard.
Because that's a reference to the disregard, exactly right. So that's the kind of its legal characteristics are. What matters is it's not that the placement didn't affect responsibility. It's I think my learned friend says it's the placement didn't affect ordinary residents under at least one of the statutes. And I can see that's not quite, I can't quite point to that in the section 117 context because it's not a deeming provision. It achieves the same result. Yeah. But my answer to that is, well, he said that's not particularly clear, frankly, from 59. And it doesn't, I mean, he wasn't concerned with the case we're dealing with. And you go on to see, there's no hint of that in 58. There's no hint of it in 60 either. So it continues. On this analysis, it follows that PH's placement in South Gloucestershire by Wiltshire is not to be regarded as bringing about a change in his ordinary residence. So the placement doesn't affect. Throughout the period until he reached 18, and this is important, throughout the period until he reached 18, he remained continuously where he was placed by Wiltshire, under an arrangement made and paid for by them. For fiscal and administrative purposes, his ordinary residents continued to be in their area, regardless of where they determined he should live. It may seem, and then he goes on to say it may seem harsh to Wiltshire and so forth. So what matters, certainly on the basis of 60 as with 58, is the placement. It's that the placement doesn't affect fiscal and administrative purposes or responsibilities. And therefore, within statutes of this nature, nor should it affect ordinary residents. That's the case. That's the case, and that's the case on ground one. Yeah. So my learned friend, as I understand it, says, well, no, it's more narrow. Cornwall, I think he says, I can tell you in more detail, no doubt, but in a nutshell, I think he says, Cornwall, of course, is not limited to just the 1989 and 1948 Acts. I think he accepts it would apply to an equivalent case involving the 2014 Act, the Carr Act. I think he potentially accepts it would apply in a different set of facts to a case involving the Mental Health Act.
I mean, if there hadn't been a second detention?
Yeah, because you can, I mean, I've encountered other cases, and indeed we've got an example of it in the bundle, but I won't take up time on it, where you might have to determine ordinary residence for the purposes of for the purpose of section 117 in a first detention case, but where immediately before the detention, a person is living in a placement under, let's say, the 1948 Act. And I think my learned friend accepts that the Cornwall logic applies to that. He can tell you if I'm wrong, but I think he accepts it applies to that situation. But he says the critical difference is that it only applies to situations where the placement is accompanied by a deeming provision. And I say, well, that's an artificial narrowing of the real logic of this decision, which is it's about preserving it's not really concerned with ordinary residents per se, it's about preserving responsibility. That's the policy of the statute. That's you know, and taken a while to get that, but in a sense that's the heart of the case, is which of us is right about that issue.
Yeah.
So those, at least for now, those are my submissions on Cornwall, and that brings me, but obviously I've covered an awful lot of the ground, it brings me just to encapsulate my case on ground one. If I'm right about that, then effectively the Secretary of State decided this case correctly. Can I amend...
In his redetermination.
Sorry?
In his redetermination.
In his redetermination, correct, yes.
He decided it.
Originally he decided it anyway, yeah, that's right. And we don't have that decision in the bundle if you want to see it.
But he originally said Swindon, as I understand it, and then he said, I'm going to depart from my own guidance.
Yes.
To decide Worcestershire.
Yes.
There's some talk of amendment.
Yes.
Was the guidance amended?
No, because there was going to be an amendment. He said in the decision he would amend it. The judicial review was then lodged. It seemed inappropriate to amend the guidance. Okay. All right. So there's a note I seem to remember there's a note on the website which says this guidance is up for amendment, but it's all pending the outcome. And then obviously then the litigation is going on. It didn't seem right to amend it. All right. So that's what's happened there.
So, obviously, so you say if I'm right.
If I'm right, then the logic applies in exactly the same way. And indeed, and I sort of tried to encapsulate, I mean, you may say this is a bit glib, but I think it's helpful and encapsulates. If you just turn up my skeleton for a moment, paragraph 43.
Yeah.
we say, and which is in the appeal bundle, the core bundle, it's page 32.
Yeah.
You can effectively transpose the facts of this case into the language used by Lord Carnworth in paragraphs 58 and 60, in the way that I set out there. So JG was living for a time, JG now, not P, JG, the instant case, was living for a time being in a place determined not by her own settled intention, but by the responsible local authority solely for the purposes of fulfilling its statutory duties.
You say that the respondent says that the critical difference, because of paragraph 58, is the difference between the placement and the deeming provision.
Yeah.
You say, first of all, that's an artificially incorrect,
Yes.
narrow reading
Yes.
of the judgment. But if that is, even if that is right, do you say here there was, in any event, a deeming provision, or is that a different point?
No, there's not a deeming provision.
Right, but there's a fixing in time.
But there's a fixing in time. That's the point.
Do you say that's equivalent for those purposes?
No, I think. I mean, the point I make about the fixing in time is it shows that the underlying policy intention is the same. And that's why you pick up Cornwall and you can apply it to the
So it does all
statute.
turn on the.
Yeah.
So you would accept that if the respondent is right to read Cornwall in that narrow way,
Then I lose.
then you lose.
Yeah.
Okay. That's
And-
helpful, thank you.
But yes, that's exactly right. But
So
just
the
to,
fixing in point time, just is the relevance of that is to put it in what I call the family.
yes, and it because
The extended family.
because it shows
It's good run.
the extended family. Yes, yes. They're cousins. I mean, all these statutes are cousin. I don't think they're twins.
Thank you.
And that's just as true for the 1948 and 1989 Acts for any others. But the reason the fixing in time is important is because the underlying policy aim is the same. So if you, without reading it out again, if you just read back, if you just think back to what Lord Carnworth says about the policy in paragraph 55 of the judgment, that is just as true for the Mental Health Act as it is for the other statutes.
Right, so you were submitting that you could transpose the facts of this case into 58 and 60.
Yeah, in the way that I do in the skeleton, I won't read all.
But you accept you can't do that for 59.
It begs it depends how you read 59, effectively. I mean, it's not... I think you would have to do a slightly bigger job of changing the language. But of course, what Lord Carnworth is... I think I'm entitled to say what Lord Carnworth is inevitably doing, as all judges do in all cases, is they are focusing on the legal problem immediately before them and the facts and so forth.
I follow that. I'm just...
But I follow that I can't quite do the kind of... It's a fair point.
It's a smorgasbord transposition in which certain bits are in, but certain bits aren't.
Yeah,
but I follow the underlying.
No, sure.
Yeah.
Sure, and I mean that brings me back to the point which I've acknowledged, which is it's quite a difficult judgment, and there are bits that point other ways, and I'm not pretending otherwise.
Fair about that.
I want to be honest about that.
You have.
But we say this is the better way of reading those paragraphs than the other.
Okay. Is there anything else on ground?
Excuse me. I don't really think there is. Well, can I just draw the threads together on some of the points that were raised at the outset? So the points against me then on this ground. First of all, the deeming provision point that we've discussed. Is that what matters?
Yeah.
And the other one is the point that my lord raised at the outset about Hertfordshire and whether that actually is binding, because that shows you that this is not a parallel statutory regime, effectively.
Yeah.
And the answer to that then is that, well, of course that was true at the time of Hertfordshire, because at the time of Hertfordshire it definitely wasn't in this sense a parallel regime, because it wasn't about ordinary residents. But whatever you make of the white paper and all of that stuff I showed you, what you can be completely sure about is that Parliament deliberately intended to bring in this widely used concept of ordinary residence into the Mental Health Act, recognising, precisely because it recognised that these statutes are being used to provide people with care in overlapping and similar situations. And in that sense, which is all that's meant by parallel regimes in the 1989 and 1948 Acts, they are now parallel regimes. And there's a definite and definitive change. So that's the point. So that is ground one, I think.
Right.
Yeah.
So I think that the only question left then on ground one that I have for you is just this, and it's, I suppose in a way it's not a question, it's just a point, but it is a point that's there. If that had been the intention,
yes, it
could have been spelled out.
Yeah.
In really rather clearer way than simply changing it to ordinary resident.
Yeah.
Which, as we know, and we look back at the cases, and whilst I accept that you would say, well, that was dealing with slightly different points, but, you know, Mr. Justice Mitting in Hammersmith and Fulham first time round says, well, there's no difference. As a matter of language, ordinary language, there isn't.
No. So, my lord...
So it's a bit of an odd thing to say, well, we made this radical change, even though our explanatory notes call them minor. But we've made this radical change, but we've done it by making a change which, in ordinary language, isn't a major change.
No. So, my lord, I would say this. I mean, it's a very astute question, and one has to be careful about intention. I'm not submitting that I can show you, by reference, for example, to the policy papers, that there's a specific intention that Parliament wanted to achieve continuity of care in second detention cases when it amended Section 117. Nothing suggests that. Nothing, by the way, suggests the other way either. The reality, frankly, as in so many problems of statutory construction which trouble the courts, is that Parliament might not have thought about that particular problem. And if the Court of... all these things are happening in parallel. So if the Court of Appeal's approach in Cornwall had been upheld, then this argument wouldn't be available. But the Supreme Court decided Cornwall as it did, and whatever some people might think of it, or whatever Lord Wilson thinks of it, for example, and he says this is all policy making.
Yeah,
he's very critical.
He says, I'm not a legislator, neither with respect to my colleagues.
It's a very characteristic...
I'm sure that Lord Wilson would be making the same point, but with knobs on, in relation to the Court of Appeal.
You mean in relation to you, or in
relation to us?
Yes, I think he would.
Legislators.
Well, yes and no. I mean, I think, let me be frank about it, I think Lord Wilson's dissent is a very... I'm not going to say it's right or wrong. It's not for me to say, but it's a very powerful. Yeah. It's a very powerful read, as it were. But it is a dissent,
of course.
And you're, and I'm not suggesting you do. No reason to think you do. But even were you to think he was right and they were wrong, we have.
Oh no, we're bound.
We're bound by
the extent
we're all bound.
It's relevant and applicable. We're bound by Cornwall.
Yes, absolutely. And in my submission, the duty of the lower court, even the Court of Appeal, is not just to kind of follow the letter of those higher decisions, but if you like, to follow the spirit and to try and encounter the spirit. And so what the Supreme Court has decided, what the majority have decided, and what they have, and the way we must understand them, is something about the general concept of ordinary residence as it is used in these kinds of statutory regimes.
Yeah.
Now, Parliament may not have specifically given thought to these sorts of problems. It almost certainly didn't. Part of what Lord Commons is saying is that he effectively identified a gap in the statutory provisions. I mean, he pretty much says so in, I think it's paragraph, paragraphs 54 to 55 are talking about there being gaps. And he's saying, but if I think it's a fair way of correction. Effectively, if Parliament had thought about it, this is what they would have done. So we're going to decide if that's what they did do. That's what they did mean. And it's the same context here. So you've got these two strands. what Parliament has done in amending section 117 is import the general concept of ordinary residence, however interpreted by the courts, into section 117. That's that strand. What has happened in the meantime is that the courts have interpreted that general concept in Cornwall in a way that has certain consequences that we've seen. And when you put those two strands together, you get the outcome which I'm contending for here. That's the way I understand that.
All right, well, let me just check.
Sure.
Do you have any
I
other
do.
questions on that?
Yes, please.
My lady has
One.
Of course, yeah.
a question.
And I'm relieved. I felt guilty that I interrupted you when you responded to my lord's question about, well, the Act doesn't say it, and I think you've now made the points you wanted to on that. My Lord, Lord Justice William Davis may be about to ask this, but does it make any difference that this was a second detention?
Well, I mean, it makes a difference in the sense that the issue
on
wouldn't.
your analysis at all?
It makes a difference in that the issue wouldn't arise but for it being a second detention.
but for that. But you say as a matter of principle.
No, I mean
it's still a placement.
It's still a placement.
By Worcestershire under its.
Yeah, I mean what the
parallel
statute requires. What the statute requires is for you to consider the not for you originally, but eventually you.
What does ordinary residence mean?
Yeah, and where was JG ordinary resident at a particular point in time?
In May 2015.
Yeah, exactly.
And this analysis is directed to.
And you have to determine that question in accordance with the principles that I've been setting out, if I'm right. And that leads you, and because there was therefore a placement, you do so on the basis the placement doesn't affect.
Thank you.
That's it. I don't know if that quite answers my lady's question.
Thank you very much.
I think it's the best answer you're going to get. So.
All right, thank you very much. We've finished your oral examination on ground one.
Indeed.
So we move to ground two, and this is on the basis that so that I have this point. Is this right?
Yeah.
Even if JG was ordinarily resident in Swindon, and therefore prima facie Swindon would be liable, Proposition 3, which is ground 2 of the appeal, is the proposition that because there's no decision by Worcestershire, ordinary resident point doesn't count.
Yeah. Let me see if I can.
Is that right?
Let me see if I can encapsulate it. If that's acceptable.
Okay.
So, I think the first thing to say about this ground or this issue, and this is a point made by my learned friend below, and he's right about it, is that in one sense, logically, this ought to arise first. We've not dealt with it first because it's of less general application, and that's why it was decision maker and subsequently in the challenges we've always put the other point first because it's of such general importance. Although I should say this is also a point of some generality. The point here, and the reason I say it's first is because if this point is correct, then at least on the facts of this case and possibly quite a lot of other similar cases, the issue of ordinary residence doesn't arise. Why is that? Well, it's as follows. What the Secretary of State says in this part of the case is that JG was already owed a duty under Section 117 by Worcestershire as a result of her first detention. That duty subsisted, it remained extant, whilst she was detained on the second occasion. Because there was no decision, that's right, but the important point for present purposes, it remained extant. And therefore, it remained extant when she was discharged. That being so, if correct, there was never any need to determine her ordinary residence for the purposes of allocating responsibility for a new Section 117 duty, because the original Section 117 duty continued to subsist. And therefore, Worcestershire, I keep wanting to say Wiltshire, Worcestershire remained, as it were, in the driving seat throughout. So that's how the point is decided by the Secretary of State. Now, that obviously raises a number of issues, only one of which is live in this court, but it's important to just say what the other issues are and see how the judge disposed of them. So the Secretary of State, having decided the case on that basis, as an alternative way of deciding the case, because it leads to the same outcome, the claimant, Worcestershire, challenged that on two bases. Sorry, I should have said... challenged it on two bases. First of all, they said, well, that can't be right, because any Section 117 duty owed to JG as a result of the first detention would terminate by operation of law the moment she was redetained. So they said, as a matter of general principle, a Section 117 duty cannot remain extant if a person is redetained. That was the first point they made, and they lost that argument, and it's not live, but it's important to be aware of that.
There's no cross appeal.
There's no cross appeal, yeah.
So the duty to provide aftercare services continued
Yeah.
even when
Yeah.
JG was detained.
Yes.
So the provision of aftercare services was a logical impossibility.
Yeah. Well, so can we just go back to the... I think it's sensible to go
Anyway,
back to...
so that was the first issue, and
Yes,
they
so
lost.
the second issue.
and you
So
said
the
there's
second
no
issue that's
possibility.
challenged, the second issue that they brought by way of challenge, let me just lay it out and then we'll go to the station.
Yeah.
Second issue they challenged was, because the Secretary of State doesn't say that Section 117 duty will subsist forever. Secretary of State says the Section 117 duty will subsist until there's a conscious decision in accordance with the statutory criteria.
Satisfied bit.
That, yes, exactly.
Satisfied bit,
Exactly.
yeah.
That it's no longer needed. Yeah, that's right. And they said, well, actually,
Yes, because this is all about the absence of a
need.
decision, and I'm very keen, if this is a matter of general importance, that it's not seen as some sort of opportunistic, look, they didn't do that, because that's how it reads. But that may be a completely
I don't think that's fair.
first impression. No, I accept that.
No, sure.
So what's the second point?
So the second point was that they said actually on the facts of this case, we did make a decision.
I see.
And they put in some evidence about that, which the judge was
notice of termination.
Yeah,
that's in the chronology.
Yeah, there's some stuff about it in the judgment. We don't have the underlying material in the bundles now, but they said on the facts of this case, we did make a decision.
Yeah.
And we said, don't be so silly, and the judge agreed with us.
So you say they lost that too?
So they lost that argument, and there's no cross appeal on that either.
No.
So they lost actually both of the arguments that they made.
Yeah.
But the judge then identified a third problem, what he said was a third problem with our approach.
Yeah.
And he accepted the Secretary of State's position that the Section 117 duty can subsist following a redetention. But he said it will cease to subsist on discharge, because at that point a new Section 117 duty arises, and, as it were, that crowds out the earlier one. I think that would be a fair way of putting it. And that's the point that's live before you. Because we say, A, he shouldn't have taken the point of his own motion, although I'm not inviting you to allow the appeal on that ground.
No.
But you can see we're a bit troubled about it. And because we weren't...
In a way, though, it's only a modification. It may be an important modification. You'll address us about it. But in a way, it's only a modification of the first point, isn't it?
It's not a million miles away. I mean,
because
I accept that.
Because it comes back to the point that I put. Because we're concerned with aftercare services,
Yes.
i.e. something post-detention.
Yes.
He found that that didn't stop at the start of detention. It stopped at the end of detention.
I mean,
before the
as I
aftercare. Wherever precisely it started, it started before the aftercare services were necessary.
I freely accept, as I say, that the judge's approach wasn't a million miles away from the argument that was being made by the claimant, but it was a different point.
Yeah, I understand.
And I think we say he should have given us a chance to address it at the very least.
Yeah.
But as I say, I'm not asking anyone to make a big fuss about that. We've no animus against the judge, etc. We just say, and it was I mainly made that point in the context of permission to appeal because you can see why.
Yeah. But having been granted permission, and
I make less of the.
So this is the chance now.
Now we can put the point. Yeah, exactly. So can I then just invite the court to go back briefly to section 117 to see how the point arises? It's tab 2, and it's because you think you do need to kind of understand this. It's page 23 of the authorities. And I've sort of made these points, but I just think it's worth reiterating in the context of this issue.
Yeah.
So the way I put it, at least, is that subsection 1 is the entry provision, and subsection 2 is the exit or the termination provision. So subsection 1 says this section applies to persons who are, you've got to be detained under section 3 or something equivalent, then ignore the middle of the, and then there's all the other powers and ignore all that. And then they cease to be detained, and then they leave hospital. Those are the preconditions for the section to apply to a person. And that whereas the duty will terminate, subsection 2, first of all, it tells you what the duty is, so that's the first half of this subsection. It's quite complicated drafting in this act, I'm afraid. But then halfway through, so the duty arises, ... and the middle of the thing, until such time as the CCG and the Social Services Authority are satisfied the person concerned is no longer in need. So what that requires, and there's no doubt about this in general, what that requires is a conscious decision that the person no longer needs the services. My learned friend's argument below was that it's implicit in subsection 1 that if the conditions set out there cease to subsist, so in other words, if you get redetained, for example, then the section ceases to apply to you. But for reasons discussed by the judge, which I don't think I need to go into, that can't be right. It proves too much, because every time you went back into hospital, for example, you would lose your section 117 services.
Sorry, what was the argument that proved too much?
This is the first point.
So if it's right, so his argument is, so the three preconditions: you have to be detained under section 3, you have to cease to be detained, and you have to leave hospital.
Yeah.
He says those things always have to remain true. So if, for example, you're redetained, then the duty comes to an end. The problem with that is that if it's right, then merely going back into hospital, for example, voluntarily, for a short period, would terminate the section 117 duty. Can't possibly be right. Because you definitely need to have section 117 in place for people who are voluntarily admitted for short periods.
Where does it refer to voluntary patients in section 117?
Well, it doesn't, but a hospital has a general meaning in the Act. It's not limited to hospital. It's not limited to detention.
No, it says this applies to, and then there are section 3, section 37, and section 45 where the
it doesn't apply to voluntary. It doesn't apply.
Right.
Voluntary admissions to hospital don't get section 117 services.
Anyway, the judge found that proved too much.
Yes. I mean, that's not a live issue.
I understand that. Yeah, that's what you say. So, yes, I see that. So that's...
So he agreed with you on that?
So he agreed with us on that.
Yeah.
So we say that you need a conscious decision about need.
Yeah.
Now, I apprehend that my Lord Justice Coulson is a little troubled about this, and for reasons I understand, I think, which is that, well, hold on, I think something you said a moment ago might imply, well, why would anyone ever need section 117 services once they're redetained? Because after all, they're being cared for in hospital at that stage. And the answer is, and it is pretty well recognised, I think, that you can need, section 117 services can include care planning. Planning for the care that's to be given. and therefore it's high. It may be then a person, if the detention is for a short period, as it was in this case, they may well need the continued involvement of the social CCG or the Social Services Authority, precisely to make plans for the care that's to be given to them on release, on further discharge. So there, you can have a case, and I have seen cases, where a person could be redetained for as a shorter period as a few days or a week under Section 3. It's pretty obvious that in that situation it's highly undesirable that the Section 117 authority should immediately cease to take responsibility the moment they're redetained, or be able to say you don't need the services, even though it's fairly well anticipated they're going to be released again pretty shortly. At the other end of the extreme, you'll have a case where the second detention endures for 20 years, at which point, well, no one, it would obviously be entirely rational for the authority to determine that the services aren't needed for the time being. Present case is somewhere in between those two extremes.
So you say not irrational for the duty to exist during detention.
Exactly, not irrational, and indeed in certain cases highly desirable. Yeah.
Okay.
So that's why it does, and that's why the statute, properly interpreted, requires that conscious decision. Now, it may be that in some cases where a person is detained for a second time, it will be a rational decision to terminate the services. But because cases will vary, they have to think about it. It can't just happen by operation of law. So that's why the duty can subsist.
So is it the words "are satisfied"?
Yes.
That create the requirement for a conscious decision?
Yes, they've got to be satisfied. I mean, you can see they actually have to. They've both got to be satisfied. So there has to be actually a meeting, and they've got to be satisfied.
I mean, they could independently come, but you can't be satisfied of something unless
think about it.
you express a decision.
Exactly. Yeah.
All right.
And outside the context of a redetention, I don't think anyone would dispute that. I mean, so Section 117 doesn't last forever. Someone's been detained on the Mental Health Act for a year. They get aftercare services for 3 years, let's say. Everyone accepts they've got better at the end of the 3 years. Perfectly legitimate for the authorities to discharge them from Section 117 at that point. But it requires a conscious decision, and that's what you'd expect. And you'd have a care planning meeting, and etc. And I simply say, and the judge has accepted this, different in the case of a redetention, you've still got to have that same exercise. And that's an entirely benevolent and beneficial reading of the statute, which is in accordance with its language. So that's, and I'm just looking at the clock, I'm conscious we're about
Don't worry, carry on.
turn into a pumpkin.
Yeah, carry on.
I was still on my feet, I'm afraid.
No, don't worry. No,
I think we're doing
covered
okay.
a lot of ground, so...
Yeah. I think we're doing okay. So it's entirely desirable and in accordance with the statutory language that the duty can, not must, but can subsist while the person is in detention, is redetained.
Yeah.
And that it will, therefore you have to have a decision terminating. There was no decision in this case. The judge has accepted, there's no cross appeal, the judge has accepted the duty subsisted, didn't terminate by operation of law, so it is, I'm entitled to say it's a premise of this appeal that Worcestershire's duty to JG continued to subsist when she was detained on the...
So the accepted duty...
Yes.
I think that's paragraph 26 of the judge's judgment. The accepted duty that existed at the time of the first detention.
Well, following the first detention, but yeah.
Yeah, but because on the test, she was ordinarily resident in Worcestershire when she was first detained.
Sure. Sorry, yes.
So there was the duty.
Yes.
And you say that duty continued.
Yeah.
And the judge found that there was no decision determining it.
Correct. So that all of that I'm entitled to say is, in a sense, I mean, I can see that the court needs to understand it, but that's the premise of the appeal, because I keep no doubt labouring a bit, but there's no cross appeal.
Yeah.
So what the judge says is he accepts all of that, but he then says even though Worcestershire continued to owe JG a duty while she was detained for the second occasion,
It stopped when she was released.
stopped when she was released. And we say, and I mean, it's a simple enough point, we say there's no warrant for that whatsoever in the statute. And it's totally contrary to the logic which...
Of the aftercare service logic.
Exactly. Because if I'm right that the reason you can have a continuing duty while you're redetained is to allow for things like care planning, then it's totally mad, it's totally mad to say...
I don't think.
Well, probably not appropriate language,
Yeah.
but
And anyway, I'm assuming that Worcestershire would say, well, of course there can be care planning. It can be carried out by the people who now owe the duty.
no,
Swindon
because
Borough Council.
because if the duty, so if Worcestershire,
This is now, and I'll leave this thought with you because we'll rise. But this is a question of sequence.
Yes.
Because I know everybody slavishly followed propositions 1, 2, and 3, but it occurred to me when I first looked at this that if there was anything in proposition 3, it came logically first.
Well, that's the point I made first, and I accept that. I mean, that's right.
Because if this is right, then the duty never devolved onto Swindon. Because you say the duty was with Worcestershire, it's accepted it was with Worcestershire, and it never changed.
That's right. That's absolutely right, and I hope I've been clear that I accept.
Yeah, no, I understand that. All right. Well, thank you very much. We will rise, and if it's all right, we'll come back at 1:55 to 2.
Yeah.
All right.
Of course. Yeah.
Thank you very much.
And I'll just say, I mean, I think it's clear that although I haven't quite finished, we're making good time. I'm going to finish.
You can't be far away because you might want to put.
We just need to nail down this point.
Put that point in slightly more sophisticated language, but frankly, it's not going to get any better than how you put it now.